Welcome back. We spoke to Andrew Cadell last week from the Task Force on Linguistic Policy. They held a public forum and talked about Bill 96, had a variety of speakers. One of them was Pearl Eliadis, who's joined us from time to time. She's a Montreal human rights lawyer and associate professor at McGill. And this, with respect to talking about Bill 96 and the challenge to it and the challenge to Bill 21, the question is, I guess, what happens if and when this does get to the Supreme Court, or maybe that's a when, because I think the if is off the table. They are, I think, going to hear this case. But what happens if nothing changes? Pearl Eliadis is on the line. Pearl, thank you for the time this afternoon. You said at this meeting, I guess in conclusion, or at some point during the meeting, that if we do not get a decision from Canada's Supreme Court on this challenge, that the next step should be taking it to the UN. Mm-hmm. To which I guess the obvious question is, what will that do and why do we need to do that? What's your concern here?
We don't need to do it, but it is one final avenue that is available if the Supreme Court of Canada says, look, our hands are tied on Section 33. It's a political deal. The language of Section 33 is really clear. There's not a lot we can do about it. And so the only thing that would be left would either be to open up the Constitution again, and I don't know about you, but the prospect of Meech Lake and Charlottetown again is not something that we necessarily want to wade in with, especially given what's going on now. So going to the UN would allow for the UN Human Rights Committee. Now, this is not the sort of corporate UN, if you will. This is an oversight body that oversees compliance with the treaty that we, Canada, and we, Quebec, signed to give its views on whether or not the notwithstanding clause is consistent with our treaty obligations. And if not, of course, it's not binding because it's not a Canadian court. But in the past, in many circumstances, Canadian governments have paid attention to these decisions, and Canada holds itself out as respecting international law. So let's see if we walk our talk.
So work with me here. If we were to do that, get a decision from the UN, from the Human Rights Committee, as you described it, that then becomes the impetus to go back to the Supreme Court and hope for a different outcome by virtue of what they've said?
No. So thanks for that, asking for that follow-up. So the way it works is that I'll give you an example of something that happened in the past, because there's actually a practical example of this in the past. So Canada used to have a provision that prevented women who had married, Indigenous women who had married out of their nation, from maintaining their status as status Indians under the Indian Act. Went all the way up to the Supreme Court of Canada. The woman who was complaining about this lost. She went to the UN Human Rights Committee. The committee said, you know what, this is discriminatory because the men don't lose their status. The women do. That view or decision came from the UN Human Rights Committee, and Canada changed its law.
Okay. So if we follow this one through the same sort of process, let's say you get that decision from the Human Rights Committee at the UN, is the thinking then that the government in power will then simply say, well, look, we have this decision, so no more use of the notwithstanding clause by governments whenever they choose to do so. Is that what happens?
Right. So in fact, as it turns out, on May 26th of this year, the Senate, the Honorable Senator Harder, tabled a bill which would sort of do what I'm talking about, which would create guardrails and conditions for the government to use or to not use the notwithstanding clause and to exercise restraint, which really was, the original intention. Michael Bergman made this point during his presentation last week. So the idea would be that the provinces and the federal government exercise restraint and create some form of legislation that would impose that kind of restraint on themselves. The other option is to open up the Constitution and fix it.
Right.
Specifically that piece.
If we go back to the original implementation, the decision to implement something like a notwithstanding clause, and I know a lot of, when you look historically at why this was done at the time, I don't think any of the provincial leaders would have thought it would be used the way it's being used right now. Is it fair to say that?
I don't know. It really was one of these things where you're sitting around a table, you're trying to hammer out a deal. I wasn't at the table, but people who were at the table say that it was one of those things that was thrown in as a sop at the last moment to have the provinces buy in. Everybody thought, "Oh my God, let's just do this." Nobody talked about it very much. People did say to Trudeau, "Shouldn't we be that we should be concerned about this?" And he said, "Well, we've had something like this in the Canadian Human Rights Bill of Rights, which we've had since 1960, and nobody gets too exercised about it. So it really isn't supposed to be used that much. Let's hold our noses and go through." So I think that's what happened. Nobody paid too much attention to it. I don't think anybody really foresaw the populist use of this as a way to just do an end run around our most important constitutional document. And I think, the task force and Mr. Cadell and the other folks who are concerned about it, raise important points.
Until such time as this particular government decided to do just that.
Exactly.
So let me then ask, with respect to the Supreme Court and the challenges to 96 and 21, the Supreme Court has agreed to hear the challenge to Bill 21, right?
Mm-hmm.
Why do you think, I guess based on how they've ruled in the past, why do you think this isn't something that can be won?
So there are several issues going up to the court in addition to the Section 33 arguments. So it may be that they granted leave to appeal on those other issues and wanted to clarify what the courts can and cannot do under Section 33. That's, I think, the most likely possibility. But there are multiple issues that are being raised that are not just about Bill 33. There are other provisions that are not subject to the notwithstanding clause. I don't want to get too much in the weeds, but there are several issues that the court will be considering. And, one thing that they might say is, our hands are tied. Section 33 is very clear. It is not the court's business to overturn the country's own constitution that we are charged with implementing. Or they may say, there are certain unwritten principles in our Constitution that we think need to be respected when you're interpreting Section 33, like protection of minority rights. The court has already said that the protection of minority rights is an unwritten constitutional principle. That argument has not worked in the past, but I think it's always important to be prudent when one is foretelling what the Supreme Court might do. So I think I'll stop there.
You said, and I'm quoting here from the piece that I read, that they've held that the clause is what you call a magical incantation. You wave around, you hit Control-Alt-Delete, and sections of the Charter, freedom of expression, right to freedom of religion, etc., all disappear. I mean, if that's the case, and if that's what sort of, this portends, why are we bothering to challenge this at all?
So first of all, it was me that said that, not the court. I don't think the court would be talking about magical incantations. But the point was that what the court did say was that there was a formula. That it's a matter of form and not substance. Once you utter the words, Section 33 applies, and those sections of the Charter, Sections 2 and 7 through 15, disappear. So in that sense, it is the Control-Alt-Delete of the Charter. Why are we going up? We're going up because it may be, as I said earlier, that the Supreme Court wants to clarify all of the confusion. The very fact that you're asking this question, and it's an important question, suggests to me that it's time for the Supreme Court of Canada to weigh in and say, maybe what we said in 1988 or whatever it was, maybe this wasn't the way to go. Maybe it's a different way to go. The Supreme Court can overturn itself. So we need to wait and see what the court's going to do.
Is there a difference between the challenge to 96 and 21?
Yes, there are different parts of different laws that are being challenged. The 96 is mainly focused on language rights. Section 21 is really about freedom of religion, and it also engages the Bill 21 also engages with the rights of school boards in a certain way to control their language and culture. It comes up in a different way in Section 96. They're not identical challenges. On the Bill 21, you'll hear religious minorities, especially Muslim women, saying this is having a disproportionate impact on us as Muslim women because we, for example, wear the headscarf. That's not an issue that's coming up in Bill 96.
Right. So 96 focused on language primarily as opposed to 21.
Yeah, absolutely right.
What just as a final question, Pearl, what's the timeline on this? We've been talking about this for so long. When does this finally happen? Do we know?
I don't think we've received. I'm not aware of any indication from the court of the date of the hearing. Normally it would be a matter of several weeks. There's a whole series of processes that have to happen. people have to make their applications for leave to appeal or for leave to intervene. So there might be parties that are wanting to come forward. There's time for the parties to respond after the leave to appeal goes through. So it's weeks, and hopefully it'll be heard within this calendar year.
All right. Pearl, thank you so much. Do appreciate the time, as always.
Always good to talk to you. Thank you very
Pearl
much.
Eliadis, constitutional lawyer who was part of that public forum. I thought I said she had said that. I didn't mean to imply that the court has said that the clause is a magical incantation. Those were her words.